Richard Nixon is not just the only American president to resign. He went to his grave never knowing of the prosecutor's secret allegations that destroyed his presidency. This is Watergate Revisited, an insider's view. I'm Jeff Shepard, your instructor in a course entitled Watergate Revisited, an insider's view. And it's being taught to the Osher Lifelong Learning Institute here at Temple University in Philadelphia. Today is week 7 of a 12-week course, and today's topic is the Plumbers prosecution, and it might better be titled The Pentagon Papers, the Church Committee, and the Hypocrisy of the Plumbers prosecution, because when all's said and done, it is probably a case that should never have been brought. Not because there was no wrongdoing, but because the wrongdoing was so circular and everybody involved comes out an unhero. But let's get started. There's 3 interrelated topics. The leak of the Pentagon Papers, which occurred in June of 1971, the creation of a task force within the Special Prosecutor's Office designed to focus on not the leak, but the reaction of the Nixon administration to the leak, and then the release within a month of the conviction of the Watergate cover-up people, of the founding of the Church Committee, which we'll get to at the end, but the Church Committee publicized in their hearings the facts that this sort of illicit entry had been going on by our government at least since 1936. So you've got swirling of interest back and forth. But let's start with the Pentagon Papers. It's not the topic, but I find it fascinating. It was written by 3 people who were the highest ranking officers within the Department of Defense that were anti-war. And they took it upon themselves to undertake this study. It took them almost 2 years to do this study. But the study was never vetted, never peer-reviewed. Department of State didn't know it was being done. The White House didn't know it was being done. And nobody else within the Department of Defense. So it's not the official position of the Department of Defense by any stretch of the imagination. It's the intellectual foundation for a group of people who turned against the Vietnam War. But the leak was a huge national security breach. And as we're going to see, the White House overreacted. Today, the Pentagon Papers have been totally declassified. That occurred in 2011. 48 volumes of paper. And you can go on the National Archives website, plug in Pentagon Papers, and up it comes. You can get it electronically. And instead of reading all 48 volumes, you can look at the index or the table of contents, and every once in a while there's a chapter summary. And you can print out the chapter summaries, and you get about a ream of paper. Okay, I did it. And then you can read it. And it reads like a novel. It is really fun to read in retrospect of what they thought and what they did 50 years ago. The chapter summaries were all written by Les Gelb, but he's summarizing studies by different groups of people going all the way back to World War II on our relationship with Vietnam. And what's so intriguing is he's a good writer, but there's different points of view at every stop along the way, and so his summaries are internally inconsistent. And unless you really think about it, it seems that it flows, but it doesn't flow consistently because the views changed. And the people who were summarizing what Eisenhower did the people who were writing what Eisenhower did may have liked General Eisenhower and cut it a certain way. And the people who were summarizing what Lyndon Johnson did may not have liked what he did, and so they threw him under the bus. And it's kind of fun to read. In any event, I recommend it to you. We're not going to do that here. I've come forward. So now we're going to whip through the Pentagon Papers. This is, it was undertaken on behalf of Secretary Robert McNamara in June of '67. The study was led by these three anti-war officers. Paul Warnke was general counsel of Department of Defense. Morton Halpern was a policy guy, and Les Gelb was a public affairs guy. It was technically completed for the Secretary of Defense, Clark Clifford, just before the Democrats went out of office. So there's a transition memo saying, here's the study. But the study wasn't done. So they shipped it off to Rand Corporation, and they worked on it for 6 months in secret in and during the Nixon administration. Daniel Ellsberg had worked on the study. He did some of Jack Kennedy's decisions with regard to Vietnam. And he made copies because he had turned, he was originally a hawk, and he had turned into an anti-war advocate and was very, very public about it. And he made copies because he wanted this study to be out to turn people against the Vietnam War. He gave excerpts to Senator Fulbright, but Fulbright wouldn't touch it because it's highly classified. And so Fulbright said, unless I get this officially, I'm not touching this thing. But Ellsberg did get the New York Times to print the first installment in June of 1971. I'm down on number 7. Okay? And there's this really interesting juxtaposition on the front page of the New York Times, because the day before was the White House wedding of Tricia Nixon and Ed Cox. So you've got the White House ceremony and the proud president, and this detailed disclosure of highly classified government information. The FBI reported to the White House that even before the New York Times printed it, that a full set had been given to the Soviet embassy. Now, they go back and forth over whether this is true or not, but there's no question that's what the White House was told. So the White House overreacted. They tried to stop publication. Prior restraint might violate the First Amendment. And they went after Ellsberg, hammer and tong, because they were told he not only was leaking and had a lot more to go on the Pentagon Papers, but because he was a consultant to Rand Corporation, he had access to 54,000 other classified documents. And they were very, very worried about what his intent was. And then, of course, the anti-war people were having an absolute ball. Senator Gavel of Alaska read the study into the congressional record. You know, he starts out and then he submits the rest of it. And the study was interesting. It stops with Lyndon Johnson. It had nothing to do with Nixon. The difficulty is they would talk about some event, and then they would attach at the end a copy of the memo or the wire or the document that they were referring to. And if you were the Soviets and you had an electronic intercept, now you had the actual document that was transmitted, so you could break our codes. No, it's not surprising that the administration took this very badly. They tried to prevent publication. They got an injunction against the Times, so the Washington Post started. They got an injunction against the Post, so the Detroit News, and then the Chicago Tribune. And in the end, within 2 weeks, with the leak is June 13th, the Supreme Court ruled on June 30th, no prior restraint of newspapers publishing. You could punish the leakers, but you can't tell the newspapers, because we don't have an Official Secrets Act. It's a place where we differ from England. So the other thing they did, the other part of the White House reaction, was to create the White House Special Investigations Unit. And they put 2 young people in charge. Its goal, of course, was to prevent leaks. That's why it's called the Plumbers. But the official name was Special Investigations Unit. And there were two people. One was Bud Krogh. Bud Krogh was my immediate superior on the domestic council, and the other was David Young. So Bud went to Principia College and then the University of Washington. He got his law degree. And he worked for the firm of Holland and Ehrlichman. He'd been raised by the Ehrlichman family. He was almost an adopted son of John Ehrlichman. And then he came when Nixon got inaugurated. He wasn't on the campaign, but he came when Nixon got inaugurated. He was a deputy counsel to John when John was White House counsel, and then he was an assistant director of the domestic council when John became head of the domestic council. And we're going to stop there at number 3 and drop down to David. And Bud represented the domestic interests in the leak and in what we're going to, the law and order answer on Ellsberg. David Young was 3 years older than Bud. He'd gone to Wheaton College, then he got a degree at Oxford, and then he went to Cornell Law School, and he worked for Milbank Tweed for 5 years. So he's an actual practicing lawyer. And then he was Henry's aide-de-camp in the first part of the administration, Henry Kissinger's. And Kissinger tended to go through people because it was just exhausting trying to keep up with Henry, doing public policy during the day, dating starlets at night. It was very hard. So David joined the Plumbers and represented the foreign affairs interests, the National Security Council interests. And then you have to understand that the Plumbers decided to conduct a break-in into Daniel Ellsberg's shrink's office to see if the shrink, if he told the shrink his plans for further leaks. The difficulty was the two people who led that break-in were Howard Hunt and Gordon Liddy, who later led the break-in into Watergate. So when the Watergate scandal hits, they're worried about what's going to happen if they find out about this prior break-in. And this is where Bud Krogh's path differs from David Young's path. They were co-plumbers. They were making decisions together. But when Hunt and Liddy came under scrutiny for the Watergate break-in, Bud chose a different path from David. Bud chose to lie to the grand jury about his knowledge of Hunt and Liddy. And David chose not to. Bud followed John Dean's legal advice. He'd helped Dean get the job as replacement counsel to the president. David Young went back to his lawyer friends at Milbank Tweed, and they represented David. So Bud, now back up to number 4 under Bud, Bud gets indicted for perjury because he had perjured himself. He pleads guilty, but he doesn't plead guilty to perjury. He pleads guilty to a civil rights violation, denying the civil rights of Louis Fielding, Ellsberg's shrink. And he's sentenced 2 to 6 years, and he serves 4 months. David Young is granted immunity in exchange for his testimony, and then leaves the country. He decides it would be better to go to England. He'd studied there. And he founds this organization, it exists today, he's just retired, called Oxford Analytica. And Oxford Analytica seeks to reproduce, based on academic input, the president's daily report that David knew and worked with when he worked on the NSC. And Oxford Analytica produces a daily report for companies and governments based on the Oxford Don's professors' reviews of what happened last night. It's very innovative. It's been very, very successful. And he's gone on, but really never recovered from time in prison. So let's talk about what the Plumbers unit did. They were established in July, on July 15th, and they immediately added Liddy and Hunt as their staff. Okay, they both Both Liddy and Hunt already worked on the White House staff, but they were added and assigned to be the entire staff for the Plumbers, other than the two co-heads. They convened a working group in the Roosevelt Room. The Roosevelt Room's in the West Wing and is the smaller room adjacent to the Cabinet Room. This is big stuff. You go into a meeting in the Roosevelt Room, the president's right across the hall, all the prestige of the White House, and they just ripped up the career people because of this leak. So they're all over the Department of Justice. What are you doing about it? All over the Department of Defense. How come you didn't know? How can you stop this? What does Ellsberg know? The CIA, the FBI, and they're leaning really hard on these people because this is a huge event. We'll come back to that in a few seconds. Then, on the 23rd of July, the New York Times strikes again, and they published the fallback position of the United States in the SALT negotiations. And of course, the West Wing and the NSC, and Henry Kissinger in particular, are going crazy. How can we negotiate when our fallback position is on the front page of the New York Times? Interesting question. Then Krogh and Ehrlichman meet with Nixon. And Nixon gives Krogh, who's now co-head of the Plumbers, about 10,000 volts of how important this is. And Bud is 29 or 30. And he comes out of that meeting as a man with a mission. Nothing is going to get in his way of doing what the president wants to bag Ellsberg and stop this stuff and stop all the other leaks. I mean, this is a holy mission now. Pat Buchanan was offered the position first. And Pat said, this isn't worth my time. You know, the Pentagon Papers are about Lyndon Johnson. They got nothing to do with us. And I don't think this is a good idea. But Bud bought in big time. Then Howard Hunt, as a member of the Plumber staff, authors this memo called the Neutralization of Ellsberg. And the idea is, well, we'll get some dirt on him and we'll publish the dirt, give it to friendly reporters, and ruin him as a spokesperson or a leader in the anti-war movement. We just got to get the dirt. This was commonly done in Washington before Nixon. You just called up J. Edgar Hoover, said, what you got? What you got on her or him? And then you'd get material if Hoover liked you, because he had files on everybody. But the idea was we need to have a file on Ellsberg, and Hoover won't help. Why? Because Hoover's good friends with Daniel Ellsberg's father-in-law, a guy named Louis Marks. Louis Marks is a manufacturer of kids' toys, and around Christmas he gives Hoover and the FBI just hundreds of toys that Hoover can give out to different charities and look like a hero, look like a normal guy. So the word in the White House, Ellsberg denies this, but the word in the White House was Hoover wouldn't help. Hoover's really getting old. He died within 6 months, and was far more worried about the FBI's reputation. He used to do illicit entries. No more, because he didn't want the FBI to get caught. So they even get Nixon to write a memo, to sign a memo, to Hoover saying, you got to get on this, you got to help. You guys, your agents aren't being aggressive enough. Krogh and Young go in to report to John Ehrlichman on August 5th. Here's where we stand. Okay, it's been almost a month since they were founded, almost 2 months since the leak. It's not taped because it's not in the Oval Office, and memories differ on what they discussed. But it's very clear on August 11th, I'm now to the bottom line here, they submit a memo to John Ehrlichman. We have it. Here's the memo. You can't read it, but I have a copy here. And on the second page, it says, in this connection, we would recommend a covert operation be undertaken to examine all the medical files still held by Ellsberg's psychoanalyst covering the 2-year period in which he was undergoing analysis. They've been told that Ellsberg went to see the shrink sometimes 2-3 times a week. Now he stopped, but he used to go. Let's go see, and the shrink won't cooperate. Something about medical privacy. He won't help. Okay, so we got to find out. So then there's an approved, disapproved blank, and Ehrlichman puts the E in approve, and he writes in by hand, if done under your assurance that it is not traceable. Okay? So what John has done, John has approved a covert operation not further described. Now, this is really important, significant, because covert has a technical legal meaning to some, and that is unknown to the host country. If you look up the Dictionary of Military Intelligence, it will say covert doesn't mean illegal, not necessarily illegal. It means unknown by the host country. Only the CIA can undertake covert operations and only overseas. But if you were assigned to review Argentina's beef situation to see how the economy was working and whether that was going to destabilize the economy, and you didn't tell Argentina you were doing that, the CIA, that's a covert undertaking. If in the course of it you break into a couple of offices, that becomes illegal. But it's not necessarily illegal. Then neither Young nor Krogh nor Ehrlichman can remember when they met with John on August 5th whether they spoke about a break-in specifically or whether they just talked about a covert undertaking. When they came out from that meeting, they told Hunt and Liddy, you guys can't do this. We got to have some separation. So Hunt says, well, I know some Cubans. Okay? Now, Hunt had been a career officer of the CIA, and Hunt was the man in charge of liaison with the Cuban community for the Bay of Pigs. He's the infamous Eduardo who gave them the goods and directed them and everything else. So he decides, since we can't actually do the entry, we'll get my friends the Cubans to do it. They're nationalists, they're patriots, they trust me. And we'll tell them it's national security, and that's why we want them to go do this. Now, the shrink's office are out in LA. So they get the Cubans, but it was very, very clear they didn't talk about or think about or have any connection with using the Cubans until after the meeting with Ehrlichman. And then when put under pressure, they can't really be sure whether or not they talked about a specific break-in. So you could bribe a nurse, you could hire a fellow shrink to go in and talk, there are all kinds of things you could have done, but that's not what they did. So Ehrlichman approves the covert operation. Hunt recruits the Cubans. Liddy and Hunt go out to do a reconnoitering visit. This is number 3. They take pictures of Liddy standing in front of Fielding's parking place. They do other shenanigans. This is where Liddy holds his hand over the candle. I mean, this is a wonderful development. They give the camera film to the CIA to develop, and the CIA says, we want nothing further to do with these guys. Don't come to us for any more help. Ehrlichman asks Colson for a plan. I'm sure that the Plumbers prepared the memo, but Ehrlichman signs it. And it says, tell us what you're going to do with dirt on Ellsberg if we find any. Okay, so the idea is we'll find out what he's doing for national security, but if we stumble across any dirt, we know how it can be used. And then Krogh calls Ehrlichman on August 30th. Ehrlichman's on vacation. He's at a payphone. The line's not secure. So Bud says, we're ready to go. Just want to touch base. But he doesn't say what it is. So Ehrlichman can reasonably maintain when the prosecution rolls around that he approved a covert operation. He didn't approve a burglary. So the Cubans do the break-in. The difficulty is the much vaunted Cuban burglars aren't very good and they can't pick the lock. Okay? So Liddy, who can't be there, hovering nearby, Liddy says, we're not coming back, break in. Make it look like a drug bust. Scatter some files. I mean, the shrink can prescribe medicine, so make it look like they were looking for pills. Okay? And they do that. Now, the difficulty, if you did an illicit entry, say to your house, and we looked at your files, but we weren't caught, you'd never know when we were there, or there wouldn't be any footprints, nothing. But if you break in and scatter files all over the floor, there's a police report. When it comes out, we know what night you're talking about. This is over Labor Day weekend. We know the specific event. Okay? Big difference. Big difference. Okay. There's what we call the ambiguity of the break-in success. The Cubans are back in their hotel room popping champagne. This was great. But they didn't find anything. There's no file. Later, Dr. Fielding testifies that the file was on the floor. It was scattered. It had been rifled. And doubters, and there's plenty of doubters, say, look, Gordon Liddy is the only guy in this break-in who wasn't working for the CIA. And it's entirely possible the CIA knew this was going to happen, watched it happen, even had the Cubans find the file, but not tell Liddy and Hunt that they found it. Maybe Hunt was in on it. We don't know. It's just very strange. They come back to the White House and report to John what they did to Ehrlichman, and Ehrlichman says, you got to be nuts. No more. Liddy is off the staff. This isn't going to happen again. That's not what we had in mind. Oh, okay. So Liddy leaves the Plumbers. Liddy's now still on Bud's staff, but not active in the Plumbers. And John Dean comes around looking for somebody to do the campaign intelligence plan for the committee to reelect the president. Bud urges Gordon Liddy on him, and John Dean hires Gordon Liddy to go over to Creep to do the campaign intelligence plan, where he messes up again. People will tell you, well, since Hunt and Liddy were this private army and they did it for the Plumbers and then they did it for the committee to reelect, that it's the same army. But no, I think we can disprove that. It's the same people, but Liddy was basically let go and Dean picked him up. Dean returns the favor later on. And then Krogh is removed from the Plumbers because a little bit later they discover that the military has been spying on the White House. And there's this, I think I told you, Admiral Wellender is running the liaison unit, and he has a yeoman Radford, and Radford is copying classified information. And they want to put a tap on Wellender's phone, and Bud declines. And so they say, well, you're not really up to this. Go back and do other stuff. So Bud's relieved of further involvement in the Plumbers, and David Young takes over and goes from there. And the military spy ring was big stuff. A lot of this is big stuff. Okay, how did the scandal unfold? They did the break-in. They weren't caught, and then they go back to their own thing. Well, in running the cover-up, John Dean, my favorite guy, he opposes any revelations as the temperature goes up higher and higher on Watergate. They say, you know, we got to start talking about this. We've got to let some stuff come out. And Dean insists that any revelation will lead back to the Plumbers. So you can't start. You got to hold firm. And he wins the arguments, even though John Ehrlichman, who's responsible in a number of ways for the Plumbers, is saying, look, let it come out. We can't just sit here and stonewall right up to the end. We'll lose everything. But Dean wins. Then Hoover dies, we're looking for a new director of the FBI. We appoint Pat Gray temporarily, but it's not going to work. So we need a director of the FBI, and we ask the Department of Justice for a recommendation. And they give us one person. Okay, guy's worked for the FBI, very distinguished man. He's now a federal judge. The difficulty in Los Angeles, his name is Matt Byrne. The difficulty is Matt Byrne is the trial judge in the Ellsberg prosecution, because we're still going after Ellsberg. So you can't really talk to him while that case is pending. I transmitted this information from DOJ to John Ehrlichman. You just can't do it. Ehrlichman says, oh yes, I can. So he goes out and meets with the judge. Now, I'm really deaf on ex parte meetings, and this is an ex parte meeting. He meets with Judge Byrne, this is number 2, and talks with him about becoming FBI director. The first meeting on April 5th goes quite well. So on April 7th, he takes him to the Western White House to meet President Nixon. Because as soon as the trial's out of the way, we're going to name him. We don't want to wait and then discover he's not interested. As soon as the trial's over, we'll name him head of the FBI. Then Dean sees this cover-up imploding, and he's been opposing any disclosure of the Plumbers. So when he switches sides and is looking for personal immunity from the prosecutors, he tells them about the Plumbers break-in. Let me tell you how bad these guys are. They've been trying to keep this secret, but they did this break-in. And then I'm on number 4 now. Henry Peterson, the head of the criminal division, Dick Kleindienst, the attorney general, tell Nixon, you've got to tell the judge. You've got to tell the judge about this break-in. And Nixon resists. But finally, within the week, he says, okay. They tell Judge Byrne, and on that same day, the FBI interviews John Ehrlichman about the Plumbers break-in. Byrne discloses his meeting with Ehrlichman, but says it was to discuss a high-level position, but there was no discussion of the Ellsberg break-in. This is April 30th. This is the day Ehrlichman and Haldeman and Dean and Kleindienst all resign. So news is just tumbling out, and Byrne says, he thinks maybe I better say something. So he says, there was a meeting between me and Ehrlichman, but we didn't discuss anything substantive. We didn't talk about the case. And then he's given a copy of Ehrlichman's FBI interview about the break-in. He gives the copy to Ellsberg's defense counsel, and they give it to the press. So this is May 1st, number 7. And then Byrne decides maybe he better disclose the second interview when he met with President Nixon and learned the position was the head of the FBI. He does that on May 2nd. Krogh then files this affidavit on the 5th, and the affidavit takes full responsibility. It says, I made the decision to do the break-in. Nobody else gave me or directed me. The buck stops with me. And he gives that to Byrne on the 5th, and then Byrne, rightfully, dismisses all charges against Ellsberg for espionage and for leaking government information due to government misconduct, due to this break-in to examine the files of his shrink. So the guy who did the leak, because of governmental misconduct, walks free. Okay? So what are the critical mistakes of the Plumbers? By and about the Plumbers. The decision to seek to enjoin publication of the papers. Prior restraint. You might have been able to tell him it wasn't going to work. To run the leak investigation from the White House. If we had said to the FBI, go find out, if FBI agents had done the entry, probably would have been successful, and they wouldn't have left footprints. But the decision to do it from the White House, I have the concept here, to play cop, huge mistake. And then not just to play cop and to run this from the White House, the Plumbers, but to actually go operational on the break-in itself with Liddy and Hunt. And I have the words FBI-CIA duet here on number 3. Because Liddy was a former FBI agent, and he was saying, I used to do these break-ins on behalf of J. Edgar Hoover. We did them all the time. Hoover just got senile and he's chicken. And Hunt would say, well, we did them. You know, we did them for the CIA. I mean, none of this, you can only operate overseas. We wanted to know. We went in. So, and I told you, Hoover, starting in 1966, Hoover said, we aren't doing this stuff anymore because we're going to get caught and Congress is not going to be nice. And I walk in, Shepard's innocent advice, they're under 3. Liddy's talking to Krug and he's complaining about Hoover being a pansy, about not willing to do these. And I said, well, you know, maybe you should get John Mitchell to talk to Hoover. Mitchell's, you know, got pretty good influence. And I walked out. You know, I had other stuff to do. So when Bud would, you know, kind of drop hints, I mean, one time he said, our men are out there tonight. I thought it was FBI agents. I didn't realize it was Liddy and Hunt and the Cubans who couldn't pick locks. So then the decision by Liddy to proceed with a break-in instead of the planned black bag job. Now, when the FBI does this surreptitious entry, they called it a black bag job. When the CIA did it, they called it a surreptitious entry. So, and when military intelligence did it, they didn't use either term, but everybody was doing it. Okay, national security. Go, do what you want. Then Bud's decision to perjure himself before the grand jury. We did a reunion of the folks who worked on drug abuse, and I saw Bud. And he was wearing the hairsuit he wears about violating Ellsberg's civil rights and what a terrible thing it was that he did. And he said, you know, I was convicted of violating his civil rights. And I said, Bud, you pled guilty to that, but you were indicted for perjury. You perjured yourself in front of the grand jury. That's the mistake. And he said, John Dean told me to. We went for walks around the ellipse. And he said it was absolutely critical. He said, lie like you've never lied before. And I said, did he tell you when he told you to perjure yourself that he was running the cover-up and he was directing people to do that to protect himself from being discovered? And I got this look, you know, like a deer in the headlights. You know, oh. Because he trusted John Dean. David Young didn't. David Young walked free. Okay. The approach to Judge Byrne about the FBI directorship when he was presiding over the trial. I mean, you know, that was Ehrlichman's decision. That was not a bright decision. And then we'll get to number 7. It's at the bottom. But the Plumbers Task Force decided to prosecute for civil rights violations and not as an illegal entry. And we'll get to that in just a minute. Okay. So Bill Merrill becomes head of the Special Prosecutors Plumbers Task Force. That's the group targeting the Plumbers break-in. Okay, another group's going to do the Watergate break-in. So what about Merrill? Well, he went to Dartmouth and then Yale. He was an assistant U.S. attorney in Detroit. And then he ran for Congress in Detroit suburbs and he lost. And then when Robert Kennedy ran for president, that brief 3-month period, he was state director in Michigan of RFK's presidential campaign. Now he's an aspiring politician. So when the Watergate break-in occurred, and when the cover-up collapsed and the special prosecutor is being established, he flies to D.C. on his own to get a meeting to see if he can't get hired, because this is a big opportunity. And he gets hired. He's a little bit older than the rest of the people. And, you know, he kind of comes in from out of town, but he's named head of the Plumbers Task Force. And he conducts the investigation, and then he's not just the lead trial prosecutor at the Plumbers trial, he kind of elbows all of his staff away. He doesn't let them do anything. And he brags about it in his book, you know, that I thought it ought to really be me. And then he goes home and he decides to run for the Senate. And that's why he leaves, to go home and run for the Senate. And then he writes a book called Watergate Prosecutor, and we'll get into it. He writes the book in 1974. It's meant to be his campaign book. if you want to run for president, you got to write a book, or for the Senate. But it doesn't get published until 2008, and he's been incapacitated by a stroke. So he was teaching at East Lansing University in Michigan, and his friends on the faculty decide to publish this book, even though it's a long time out of date. And the guy who helped to get it ready, Bill Merrill's incapacitated, so they can't talk with him. He clearly wasn't a lawyer, and we'll see, there's some quotes that are coming up, because what he puts in that book is nothing short of incredible about how they went about doing this and what they were doing. So that's Bill Merrill. Let's go to the backstory on the trial itself. And this is the first of 2 slides, and I have 27 facts. So forgive me if I go through them quickly. As I say, there's more information than you need to know. So Krogh and Young testified before the grand jury during Earl Silbert's investigation that followed the Watergate break-in. They want to know the background of Hunt and Liddy. And I have highlighted David Young in blue because he testifies on August 25th. Okay? Bud comes in 3 days later. David's told him everything about Hunt and Liddy. Bud comes in 3 days later and lies. And they can tell open and shut that he's lying because they just got the other story from David Young. Then he puts in this affidavit saying, I did it all. Merrill's named head of the task force. And then Merrill undertakes, this is number 4, 52 hours of interrogation of David Young. Because David's been given immunity, and David is taking the position, not unreasonably, that the President of the United States, as Commander-in-Chief, has the authority to conduct wireless searches in the name of national security. Okay? And the way we summarize that point of view, you don't have to agree with it, but the way we summarize that point of view is there's no national security exception to the Fourth Amendment. Fourth Amendment guarantees you freedom from unreasonable search and seizure. That's why we involve the courts. But the administration has maintained forever that they don't have to involve the court if it's national security. And David is saying, look, that's the position of the Plumbers, and Bill Merrill wants to flip him because he wants to tell a different story. And David won't do it. So they lean on him and lean on him and lean on him. And when they do the prosecutive memo, remember when you get a prosecutive memo, you got to state what the weaknesses are of this particular witness. And one of the listed weaknesses is we've been browbeating this guy for 52 hours. You know, and if the defense ever learns about that, they're going to be wondering what we've been doing. Then Phil Locavara, number 5, sends a memo around saying we have files documenting all past government intrusions. They're kept in the special prosecutor's office, but if you want to see them, let me know. So they know about what's been going on before. Krogh's indicted for perjury of his grand jury testimony in August 29th. Merrill meets with him in October 19th, I'm on number 7, to convince him to plead to a civil rights violation, violating Fielding's civil rights rather than perjury. He says, if you cooperate with us, we're trying to make a case against Ehrlichman on violating civil rights because John didn't perjure himself. But it'll be easier on you if you plead to that. Bud tries a national security defense, and Judge Gazelle shuts it down. He says, nope, we're not going to accept that defense in my court. Bud's lawyer goes in and says, if he lied, of course he lied, if he lied, he did so to protect national security. And Gazelle says, speak no further, that's not an option. There is no national security exception to the Fourth Amendment. So Bud pleads guilty to the civil rights violation. They're going to go easier on him if he does. Ehrlichman meets with the prosecutors on January 10th, and he starts complaining about selective prosecution. And in his book, Merrill says, imagine that. You know, here's this guy, he's done all this wrong, And he's saying we're being selective in those people that we're prosecuting. Doesn't mention it goes back to 1936. Jim Vorenberg, I'm down on number 11. Jim Vorenberg has taken notes of all the meetings. And there's a discussion in the senior staff meeting of Jaworski's that this is not bright. We should not go into court and say there's no national security defense. Let's not do it that way. Let's prosecute them for a simple break-in. So there's a discussion about whether this is a good idea or not. But in the end, Ehrlichman and Colson are indicted for civil rights violations. Okay? And Judge Gazelle then has a conversation in private with Merrill about the case. Okay? And we know the date of that conversation. These ex parte meetings aren't supposed to happen. We go on. I'm hurrying through this. Nixon writes Judge Gazelle and says, this was national security. I meant to delegate. I didn't know about the break-in, but I meant to delegate the strongest emphasis that these people should leave no stone unturned in trying to figure out what Ellsberg was likely to do. Colson, who's indicted with Ehrlichman for the same thing, Colson claims the CIA is planting derogatory stories about him, and he produces 39 volumes of newspaper clippings to say they're trying to take attention away from one of their cover operations, and they're blaming me. And I've got to be allowed to go through their files because the CIA wants me to take the fall. The Vorenberg meeting notes again note there's concern with Merrill's approach about civil rights violation. Gazelle rules against Ehrlichman's national security defense. He says you can't offer it. I'm working with Fred Bizard. I'm his deputy. This morning, this is on June 3rd, 1974, number 18, he says, you better buckle up your seatbelt. There's going to be real fireworks today. Colson has made a strong case against getting records from the CIA. The CIA has refused to turn them over. Gazelle has said, if you won't turn the records over, because he needs them for his defense, I'm dismissing him out of the case, so take your pick. Today, we're going to say we will not give you the records. And Gazelle's going to dismiss the case against Colson. All heck's going to break loose. So, okay. So they go down, they get ready. I don't get to go. They get ready, and Colson announces he's discovered Christ and he's going to plead guilty. And there's this switch, to our great surprise, and Colson pleads to a civil rights violation. And Bizard had just assured me Colson was going to skate free, or at least at that moment, Colson was going to skate free. So then Ehrlichman tries it. Let's go get some records. You know, how can you try me with Gordon Liddy, who did the break-in, when my defense is I didn't authorize the break-in? They've got to be separated, and they won't give me the records either. And Bizard produces an affidavit that says there's nothing in these records that would help Ehrlichman. And the next day he has a heart attack because he's basically undercut Ehrlichman. Now, go back to that meeting in the Roosevelt room when they're just leaning all over people for the leakage. Bizard is general counsel of the Department of Defense. He's in that meeting. He's on the receiving end. Okay? Life goes by. Now, he's counsel to the president, and the guy and Krogh and Ehrlichman that were leaning on him so hard need some help. Help's not forthcoming. So, Bizard gives the affidavit. Bizard has a heart attack, survives. The Plumber trial begins on June 28th. I testify as a chain of custody witness, high moment in my young life. Gazelle instructs the jury there's no national security defense. So any covert undertaking by the government to review your files under any circumstances without a court warrant is per se violation of the Fourth Amendment. Okay? He rules that as a condition of the case. That was John's only defense. So he basically directed the jury to find him guilty. John is convicted on July 12th. He sentences him to 20 months to 5 years. And then the cover-up trial occurs after, and Krogh and Young are brought back in at the cover-up trial to testify again about the Plumbers break-in for 3 days. And John says, this is double jeopardy. And they say, no, 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 these are just witnesses. We have a right to explain to the cover-up jury your wrongdoing about the Fielding break-in. The Department of Justice, this is 26, submits an amicus letter on the appeal, because John takes the appeal saying, you can't do this to me. And the Department of Justice says, we maintain we can do these. You know, there is a national security exception, but John wasn't authorized to say that was okay. So please don't rule that, as Gazelle just did, please don't rule that there's no national security defense. And the Court of Appeals upholds John's conviction, but not on Gazelle's decision. They uphold it really on the DOJ representation that this was just an illicit burglary. I know this is confusing as can be, but that's the way it came. Okay, so what does Merrill do? Merrill has just won big time. He goes off to run for the Senate, and I have the letter here, and I'm going to read it to you. This is a letter dated August 18th, 1975. The last time we talked about our contribution to Colson's legal career, they got him disbarred, I mentioned that I was exploring becoming a candidate for the Senate. It now looks like a realistic possibility. I'm spending much time trying to get public exposure and to raise enough money for a PR firm. In this latter endeavor, some of my advisors have enthused over the idea of inviting you as the guest of honor to a private fundraising event for me here sometime before the end of the year. And then on the side letter, you have his formal resignation, which occurs 9 days after his letter on private stationery asking for Jaworski to come help him campaign for the Senate. I don't think Jaworski went. I can't find a record. And Merrill didn't win in the primary. Dunn Regal won and replaced Phil Hart as a senator from Michigan. But you have a prosecutor with naked political ambitions who's bringing this case, and he wants to bring the case to help him, I say, to help him to run for office. So here's this book, and we're going to get, we're going to dwell in the book. 1, he's got naked political ambitions. 2, he talks to the judges ex parte. 3, he flips Krogh from perjury to civil rights. 4, he badgers the witnesses. 5, there's non-disclosure to the defense of prior government break-ins. And 3rd, and we'll get to it at the end, it's the hypocrisy of his claimed success. These are the ex parte contacts with Sirica and Gazelle. And this is out of his book, okay? I began discussions in the office how to explore how we could persuade Sirica to assign our case to another judge. We preferred Gazelle because his previous familiarity with the case through Krogh's indictment for perjury and subsequent guilty plea to the break-in. Gazelle's already ruled on the key issue that we want to win on, so why don't we go get Gazelle? Next day, there was a newspaper story saying the other judges were unhappy with Sirica's attempt to retain control. I discussed my suggestion further with Leon, that's Leon Jaworski. He agreed to mention it to Sirica. You know, we get together every once in a while, talk about things. My efforts were successful on March 8th when Sirica signed it to Gazelle. We then had to position our case with Gazelle so it could be over far enough in advance of September 1st to allow Ehrlichman and Colson sufficient time to prepare for the cover-up trial. Otherwise, there might not be a trial of our case. If their case were to come after the cover-up trial and everybody was convicted, there'd be no reason to bring the case. So Merrill, in order for him to try the case, he's got to have it occur before the cover-up trial, which has been noted to start on September 1st. So we received some help in this from Judge Gazelle. The possibility of having the break-in trial first also occurred to him on March 11th. He called me and asked my views on the order. I replied, I would have to discuss it with Leon, but I added our case might only take 2 weeks unless we encountered problems with the defendant's national security claim. He seemed quite surprised. In my prediction on the length of the trial, I discussed it with Jaworski, and we decided not to take a position. Well, he's already taken the position in an ex parte phone call with the judge, and he's told the judge, look, as long as you keep national security out of the case, we can do this mother in 2 weeks. You know, let's go. On April 11th, Gazelle set the time on June 17th for the trial of the Fielding break-in. So we get to do it first, okay? Then he's got to flip Krogh. Remember, Krogh perjured himself. We got to have him plead to what we're going to try to convict Ehrlichman and Colson. Early in May, Krogh filed an affidavit with Byrne, which he claimed full responsibility. We decided to use Krogh's reputation and conscience to our advantage. First step was taken in October when we charged him with perjury. Krogh and his attorney were stunned by our strategy to charge him with perjury. They were even more uneasy when Gazelle wanted an early trial. Schulman, that's Krogh's lawyer, tried to avoid the impending disaster to his client by filing motions in which he claimed if Krogh perjured himself, it was justified on grounds of national security. Gazelle rules against that. That's why we wanted Gazelle to be our judge. We were far more interested in a guilty plea to the break-in than a perjury conviction. Such a plea would have much greater ramifications in support of the constitutional principles involved. On October 19th, I met with Krogh and Schulman. After discussing the certainty of a conviction for perjury and the fact that it would result in permanent disbarment, I described the other way, that he could help, let me get it right, a guilty plea to the break-in. Most importantly, it would be beneficial to the country for helping prevent such improper activities in the future. In the connection with the last suggestion, I stated if Krogh really believed the break-in was wrong, he was morally obligated to plead guilty and to make some public statement. I stressed this was the only way Krogh could help prevent such conduct in the future. This is his book he's writing for his campaign. Okay, you know, I appealed to his patriotism, come plead our way so we can convict your boss. So, and then Krogh goes soft on him, okay? With Krogh, the effect of prison caused an unexpected problem. I talked with Krogh at the end of May in prep for the June 17th trial. It was the first time I'd seen him since he began to serve his prison term. He seemed more subdued than at our last meeting. I was shocked when early in our session he said something to the effect that he probably had not said anything to Ehrlichman about the Hunt-Liddy project prior to August 11th. That's the memo. Until then, he had difficulty remembering what had been said, but he never said he might not have said anything. All I could think of was this was a result of being in prison where you don't squeal on anybody. Deciding to take a calculated risk, I slammed my hand on the desk and I shouted, "God damn it, Bud, that's the first time you ever said anything like that. Is that what you have learned from your fellow prisoners? If that's how you intend to implement what you said to the court about being sorry for what happened to Dr. Fielding, then you can go to hell. I won't intervene. I won't interview you further. I'll call you as an adverse witness and cross-examine your ass off." And I strode out of the room, hoping I hadn't gone too far. My shock treatment worked. Krogh folded, said, "Well, I guess I'll see it your way." We call this browbeating the witness. Normally, you can't find proof of it, but he's written this book, and he brags about it, and then some yahoo 40 years later publishes the book without taking that out. Okay, at the end of the book, he wraps himself in the flag and he says, 2 successes. Since those who don't remember the past are condemned to relive it, it's essential to preserve the lessons of Watergate. The investigation and trial had 2 important results. 1, Colson's guilty plea to having violated Ellsberg's rights. Now because of that, government officials cannot publicly attack controversial figures who've been indicted and are awaiting trial. Now, in your short life, you may have noticed there's always news coverage about people who are indicted and are waiting for trial. The prosecutors and the defense lawyers are fighting over the potential jury pool. It goes on all the time, but fortunately, Bill Merrill, in bringing this case, has stopped that. That's his first success. And his second success is a result of Krogh's guilty plea. As a consequence, government officials cannot break into citizens' offices on the basis of their own determination of what constitutes national security. He's now arranged for the court to rule, Gazelle, to rule that no entry, no covert entry can occur in the name of national security. And of course, they occur all the time. They've been occurring since 1936, but Merrill is claiming success for that too. So we go on. This is the letter that the Department of Justice submitted to the court on appeal. And you got to read it with a grain of salt, but it says, for God's sakes, don't rule that way because the government needs this. And they go in, and I won't read it to you, they go into detail. They say, listen, there was no authority to do this in the first place. It was just an unauthorized burglary. Uphold it that way. And the court does. And the court does. And then, and this is really cool, this surfaced very, very recently. This is an email from another fellow. And at the top of page 2, it says, I was looking into the files on the Plumbers, and the FBI has removed certain documents from that file. The FBI pulls stuff that they don't think is appropriate for sharing. And in the explanation of what they pulled, they said, and this is a quote, the FBI believed the inference is likely to be drawn by congressional committees that this committee, this is the working group trying to stop leaks, was a prelude to the Watergate affair and the Ellsberg psychiatrist burglary. The committee in question is the Interagency Committee on Intelligence. So the FBI has pulled material from the file because they're a little bit worried in retrospect it may not have been Krogh who decided to go in with the illicit burglary, but the whole working group was talking about it. But we've moved the stuff. Okay, we're going to switch. I've bleated enough about the wrongdoing of the prosecution. There was wrongdoing. The prosecution had wrongdoing. And then within the month, up pops the Senate's Church Committee. And this is really something. So here's your picture. It's created by the Senate in January of 1975. That's the month the cover-up guys are convicted. And it's got 5 Democrats, Frank Church, Phil Hart, Walter Mondale, Walter Huddleston, and Robert Morgan and Gary Hart. 7, 1, 2, 3, 4, 5, 6. And 5 Republicans, John Tower, Howard Baker, Barry Goldwater, Charles Mack Mathias, and Richard Schweiker. The Republicans refused to sign the report. These people have all watched the Irvin Committee, watched everybody get famous. They think they're going to do it again. They wanted Phil Hart to run the committee, but Phil was too ill. So it devolved to Frank Church. Frank Church is the boy wonder from Idaho. He's never run a big committee before. He wants to run for president. There was all kinds of wrongdoing coming to light because Hoover had died and Richard Helms, was sent over to be our ambassador to Iran. And their successors answered the questions of the committee. You want to know what we've done that's not appropriate? Let us tell you. And it could have been worked out. Let's not do that anymore. But Frank Church wanted the publicity because he was going to run for president. So they plaster this all over the front pages. And let me give you a sample. We're running a little over, but I don't care. Nearly 250,000 first-class letters were opened and photographed between 53 and 73 by the CIA. At least 130,000 first-class letters were opened and photographed by the FBI between 1940 and 1966. Some 300,000 individuals were indexed in a CIA system, and they created separate files on them. Millions of private telegrams sent from or to or through the United States were obtained by NASA between 47 and 75. They read anything they wanted. 100,000 Americans were subject to Army intelligence files. Intelligence files of more than 11,000 individuals were created by the IRS between 69 and 73, and tax investigations started. At least the bottom one, at least 26,000 individuals were cataloged on an FBI list of persons to be rounded up in the event of a national security. What's so intriguing, it's just scary. I have the book. Here you go. If you'd like to stay awake at night, not go to sleep, read this book. It divides it into 3 groups, kind of before Eisenhower, during World War II, and then Eisenhower and Kennedy, and then Kennedy and Johnson, because it's done by the majority staff, and they want to protect Jack Kennedy. But if you read inside, you read the stuff they were doing, it's nothing short of incredible. All these wiretaps on Martin Luther King that Bobby Kennedy personally approves, Lyndon Johnson bugging the Mississippi delegation to the 64 convention, and the FBI having a line right into the White House so he can maintain what's going on. I mentioned the ideological organization audit program, which resulted in 10,000 IRS audits of people who gave to conservative causes. Nothing short of incredible. What happened? If you were classified as subversive, you lost your rights. And it started out with the Germans. We were fighting them in World War II. They got no rights. And then it switched to the commies. We were against the commies for a long time, and Hoover was really against the commies. And he thought Martin Luther King was a commie, so Martin Luther King had no. They bugged his home, they bugged his hotels, they bugged SNCC, Student Nonviolent Leadership Conference, the Nonviolent Coordinating Committee. I mean, just people after people after people. And then they started bugging civil rights agitators, because they had to be commies, so we'll go bug them. They were subversive. And then they started bugging women, women's libers. They were upsetting the natural order of things. So if you got too far out front, they'd bug you. And then they started bugging the anti-war activists because they were subversives too, okay? So if they classified you as a subversive, you had no rights. Now go back to our favorite justice, Robert Jackson, who gave that famous speech to the U.S. attorneys in 1940, and I happened to notice it, and I'm going to read it to you because it's just superb. In times of fear or hysteria, political, racial, religious, social, and economic groups, often from the best of motives, cry for the scalps of individuals or groups because they do not like their views. Particular do we need to be dispassionate and courageous in those cases which deal with so-called subversive activities. They are dangerous to civil liberty because the prosecutor has no definite standards to determine what constitutes a subversive activity, such as we have for murder or larceny. Activities which seem benevolent and helpful to wage earners, persons on relief, or those who are disadvantaged in the struggle for existence may be regarded as subversive by those whose property interests might be burdened or affected thereby. Those who are in office are apt to regard as subversive the activities of those who would bring about a change of administration. Some of our soundest constitutional documents were once punished as subversive. We must not forget that it was not too long ago that both the term Republican and the term Democrat were epithets with sinister meaning to denote persons of radical tendencies that were subversive of the order of things then dominant. I've got 2 more slides. I mean, he's right on, and we were doing it. We were doing it when he wrote this. We were doing it for 40 years afterwards. So what are the ironies of their findings? They put it in here. These entries have been routinely done since 1930s. That's where they stopped their review. They didn't go back before. Nixon's been castigated for the Houston plan, but the Church Committee says it's little more than an update of a contingency plan in place since 1952. The Nixon administration did a FBI check on Dan Shore, but the FBI JFK had the FBI wiretap Martin Luther King at least 17 times, as well as a New York Times reporter and his secretary. And of course, more recently, the Obama administration tapped AP and my friend James Rosen. They castigate Nixon for not objecting to Dean's idea for 17 audits, and yet Jack Kennedy's ideological organization program triggered audits of 10,000 people. And they say Nixon didn't react aggressively enough to Watergate bucking, but he'd been bugged in 60, 62, and 68. If you read this stuff, and the scariest one are these interviews from the 2 FBI liaisons to Kennedy and Johnson administrations, and they say, oh yes, we did that. Oh yeah, and they show them oh yeah, but it was the only instance I can remember. Document after document after document. And Howard Baker was on the Irvin Committee, and he's on the Church Committee, and at one point in the FBI, he says, how come you didn't tell us? And then he thinks, oh well, never mind, let's go on. But it dawns on him that if this had been known during Watergate, the outcome might have been different. I quickly summarize. The real wrongdoing was Krog's decision to go operational. When you really get down to it, there's lots of wrongdoing. Man, that was a humdinger. The principal reason for bringing the prosecution was Merrill's quest for personal glory, and Phil Heyman, who's a Harvard professor, he wanted to get the court to change this long-standing policy that you can't do wireless entries, warrantless entries. If he had said that when he was a part of the Johnson administration, he was in the Department of Justice, they would have squished him like a bug. But now he's a Harvard professor, so he says, oh, let me help you with this argument. He comes down from Harvard to do the arguments in front of Judge Gazelle, and he prevails with Gazelle. He doesn't prevail on appeal. The prosecutors knew and hid the record of prior government intrusions. They cheated. I list the whole thing of cheating. The Church Committee is an example of a Watergate reform gone wrong. Be careful what you ask for, because some people maintain the disclosures, and those files are never going to become unsealed. There's no schedule for the Church Committee records. But there's lots of people who would tell you the walls built between the FBI and the CIA in light of the Church Committee disclosures prevented the exchange of intelligence that culminated in the 9/11 attacks. I mean, this ball doesn't stop bouncing. And that, my friends, concludes my presentation. We're now willing to take questions. Forgive me for going over. I really try to give you a half hour. Sir?
I'm just curious, in your time at the White House, what was the feeling like in terms of the working relationship? Was there a panic situation or just business as usual?
The question is, when I was on the White House staff, was there a panic situation or was it just business as usual? It was business as usual until April 30th, when Haldeman, Ehrlichman, Dean, and Kleindinks departed. We then evolved into what was properly described as a bunker mentality. The distinguishing characteristic, as it was explained to me, of a bunker mentality is when the hand grenade comes in to your foxhole and you got to throw it back out. It doesn't matter what direction you throw it in because you're surrounded. There was nobody left willing to defend the president except the president's immediate staff. Now, working for Bazart, I didn't mingle. I mean, so I wasn't out chatting with the speechwriters or the congressional relations guys because I couldn't talk with them about what we were trying to do. You don't want to ask a question. You're just fixing your eye.
I'm looking at my
Sir.
I thought the last bullet on your last slide said something about leading to 9/11.
Yeah. Right.
What were you trying to say there?
After the Church Committee, they built a wall, a Chinese wall, where the CIA couldn't share its intelligence with the FBI. It's Jamie Gasorch, doesn't matter. She was Deputy Attorney General. They enacted regulations that said you two can't talk because the CIA is only international and you're only domestic. And in the 9/11 hearings afterwards, the Attorney General appeared and said, quit picking on us. You guys imposed this requirement that our people couldn't talk. If we could have talked, we might have uncovered this plot and prevented the carnage. Sir.
Keeping secrets is an obligation of the executive branch. Why didn't they trust CIA and FBI to plug the leaks? Was it lack of control? Would they lose control over the operation? Or did they not think that they would go after them?
Why didn't, when the Pentagon Papers leaked, why didn't the White House work with and through the FBI and the CIA instead of deciding to do this themselves? Ego. Bud was really eager. The president had charged him with this responsibility. We had success in drug abuse. We brought the drug abuse treatment and law enforcement into the executive office of the president and directed the agencies from the White House. And Bud had done that very successfully. So he concluded he could do that with this leak. Huge mistake. Now, there was this talk that Hoover was getting old and Hoover wouldn't do it. And the CIA's, you know, they're not your best friend. Richard Helms took the position that the CIA services one president at a time. When Nixon left office as vice president, DM was head of South Vietnam. We had missiles in Turkey, and and we could invade Cuba if we chose. And when he comes back in, he says, you know, all this changed. What happened? And Helms says, can't talk to you about that. Can't talk to you about, I'm sorry, can't talk to you about that. And so there's this tension. And there's always going to be tension. The Houston plan, I have time. The Houston plan was what to do in the event there is a sufficient national upset that you can't hold an election. And it was kind of, what do you do except charge martial law? It was a scary plan. But one aspect of the plan was, instead of the FBI doing these investigations, we'll have a committee. And the committee will consist of the CIA and the head of Defense Intelligence and the FBI and one or two others. We'll decide how far the FBI ought to go. And Hoover said, no. This committee's not making decisions that I have to go execute, because when somebody gets caught, it's going to be me, going to be the FBI. So the plan was only technically in place for a week, and Hoover went to Mitchell, and Mitchell said, kill it. So John Dean turned it over to the prosecutors. It became a cause célèbre, but it was never really in effect. And it was Hoover. I mean, blow hot and cold on Hoover. But it was Hoover who said, we're not having a group make these kinds of decisions, sir.
Why did they throw, did he think nothing would happen if he perjured himself?
No. He didn't think nothing would happen. He trusted John Dean. If you go back far enough, it just, he's the one who first approached John Dean about switching from the Department of Justice to the White House to take John Ehrlichman's place. Bud thought of himself as an uncle, an elderly commentator to John Dean. I went in once, remember I'm here, and I complained vociferously because I was working on a project. Dean was supposed to help, and Dean didn't do anything. He didn't work. I mean, he was partying. You couldn't get him to be responsible for anything. And Bud said, I'll take care of John. I have a special relationship with John. You don't have to do that anymore. Well, Dean sure helped him out. And he said, you have to do this. You have to do this to protect the president. That's what Jeb Magruder said to poor Bart Porter. Jeb Magruder's chief of staff at the committee to re-elect. Liddy got $80,000. What did he do with it? Bart is assistant treasurer. They can't convince Hugh Sloan, who's treasurer, to lie. So they separate out Bart, and Magruder calls him in and says, we're looking for people whom the president can trust. We need your help on this. And Bart went down to the grand jury and perjured himself. He knew what he was doing. I mean, in retrospect, you just can't. But Nixon, I jump around. Nixon says on the tapes, these people who did the Watergate break-in, what did they think was going to happen if they got caught? Did they think we were going to call up the Attorney General and say, turn your back? Gordon Liddy, okay, ex-FBI. He thinks he is so cool. I do these black bag jobs. He's not even a good crook, okay? He messes up the Plumbers break-in. He messes up the Watergate break-in. He messes up laundering the money. I mean, and everybody thinks, what a hard guy. He wrote this book. Isn't that neat? I mean, it's an incredible situation. You can't believe it happened.
And explain again why him changing his plea to
Sure,
the
from
civil rights
perjury,
violation,
well,
what was the significance?
Good question, because I skipped. The question is, go over that switch from perjury to civil rights violation. I don't fully understand. Bud committed perjury. They had him cold. Pleading guilty to perjury wouldn't help the prosecution. Phil Heyman, and I skipped this part. Phil Heyman is this Harvard professor who's down working with Archie Cox. And Phil wants to create the precedent that you can't do warrantless entries anymore. He knows they've been doing it. And so what he wants to do is use the Plumbers prosecution with this very liberal judge who's already agreed there's no national security exception to the Fourth Amendment. And so they decide to prosecute Ehrlichman and Colson on the basis of civil rights violations. If Bud pleads, yes, that's what I did, it strengthens their case. They put him on as a witness. Then they got Colson to do the same thing, to plead to a civil rights violation. So they're on a roll, but it's made up. This is a reinterpretation of a law that was passed back after the Civil War. It's got nothing to do with what we're doing. It's a very, very creative reinterpretation. Think of the Logan Act today, which the prosecutors have fastened on to make policy on the basis of a single judge. And they turned the whole thing around, and the rest of the staff, the rest of the special prosecution is very worried about doing this. They don't want that trial to come first because it's so weird, and they don't like that position. But Phil Heyman and Bill Merrill prevail because they got Judge Gazelle picked to try the case. Okay? Sir.
So Jeff, if that's the case, what happened did Ehrlichman appeal his conviction?
Oh, very much so. And that's when the Department of Justice puts in that letter that says, don't rule on civil rights. I mean, it's disguised, but there was no authority to do this break-in, because if there had been authority, it could only flow from the president to the attorney general, who had to personally approve, and that wasn't done in this case. Ehrlichman didn't have the attorney general's concurrence. So they're begging the appellate court, rule on a different basis. And it's really strange because they uphold, I think, 3-zip, the conviction, but 2 of them in their concurring opinion say, yes, there is no national security exception. So they could have, but they took mercy on the Department of Justice and decided not to uphold on that basis.
And that was the final decision?
Yeah, the Supreme Court, with a single exception of the Tapes case, never granted cert on any of these cases. Well, wisely so. One more question? Sir.
Yeah, does the amicus brief have any power? I know it doesn't sometimes in the state court.
No, it has no power. It's just advising the court. But the Solicitor General, who didn't submit this is the acting head of the criminal division, the Solicitor General is frequently talked of as the 10th justice, because the solicitor who works at the Department of Justice represents the government's point of view, which holds real sway with the Supreme Court. So they don't always win, but they're taken seriously. It's not like me. Thank you very much for coming. We'll see you next week.